Let's have our next conversation. The chairman of the Economic and Financial Crimes Commission, EFCC, Laundering, has called for stronger collaboration from designated non-financial businesses and professionals with the EFCC against money laundering and in tackling the vulnerability of major economic sectors of the country to the crime. I will also look at the existence of high-profile convictions to international pressure and financial sector reforms. The Nigerian government has made some strides, but is it enough? Are these efforts generally curbing the problem, or are we just scratching the surface? Today, we take a deep dive into Nigeria's ongoing fight against money laundering, examining the legal framework, the role of institutions, the challenges in enforcement, and what must be done to strengthen accountability and transparency. Joining us is Mohammed Usman, legal practitioner, public affairs analyst, who will help us unpack the realities behind the headlines and what the future holds for Nigeria's anti-money laundering campaign. Good evening to you, Mr. Usman. Good to see you again. Thank you so much.
Good evening, and thank you for having me.
Thank you very much. So, like I said in the intro, I was listening to Olaolukoide during an interaction with some members of the designated non-financial businesses and professionals. He emphasized why Nigeria's standing in the global financial system depends significantly on how well we implement the anti-money laundering, countering, financing of terrorism measures across both financial and non-financial sectors. It says non-compliance exposes the nation to grey listing and international restrictions, which hinders economic development. Is there genuine political will behind the anti-money laundering efforts, or is it more of a performative gesture?
Yes, actually, the situation is a kind of delicate one, if I can say. Of course, there are available legal and institutional framework for the purpose of enforcing those issues surrounding prevention and detection and even prosecution of money laundering and its offenders. And also, on the other hand, there is significant success, if I can say that, with the institution that is saddled with such responsibility, particularly the ICPC. Of course, you will agree with me that of recent, I'm aware of convictions that had been achieved by the Economic and Financial Crimes Commission in that respect. This cut across a lot of courts, and of course, we can't. If at all, Nigeria as a country is going to be deliberate and committed in combating the issue of money laundering, then definitely within the Nigerian landscape, corruption is at the top tier as one of the means whereby illicit funds are acquired and then they are laundered. Which is an offense by the law. So as far as within the corners of our institutions, corruption is not deliberately tackled, is not deliberately eradicated, then the issue of money laundering has come to stay. Of course, there are a lot of processes whereby money can be laundered. Corruption is only one of them. There are so many of them, issues of drug trafficking, issues of sex trafficking, and others. They all contribute towards the proliferation of money laundering within the landscape. But then corruption in Nigerian context is a major, I repeat, is a major contributor. So as long as we are not deliberate in trying to eradicate corruption within our system, then definitely money laundering has come to stay. And we might not be able to see the results that we desire as far as the prevention of the said crime is concerned.
Because I'm eager to know to what extent is this fight against money laundering hindered by corruption within government agencies? And also, how can government build public trust in the integrity of its fight against money laundering?
Yes, of course, there are many ways that the state can do that. Believe me, one of them, I believe, is making investigation and arresting suspected offenders who have committed money laundering, and also prosecuting and punishing them before the court of law without fear or favor, and also without any form of interference by the state agencies. Because mostly the accusations goes to the effect that the people that got these monies and then want to convert them so that the monies will look will legitimate, mostly public officials in Nigerian context, because the institutions, particularly non-designated financial institutions, you find out that they are only front organizations that when these monies are supplied, they are taken into these institutions so that they can be fronted. So as long as these things have not been tackled against, then we just be oscillating where we are. So first of all, there should not be fear, there should not be any favor on the part of the state in respect of this. There should not be biases. No one is above the other. We're all equal on the eyes of the law. So anybody that is caught wanting should be taken in, and appropriate measures and legal standard should be taken against that person. That is one. And of course, at the level of prosecution of these cases, there are instances whereby you find that the institutions prosecuting these offenders are lagging behind in some respects. They have their own reasons, but then the state can do more in respect of seeing that they prosecute these offenders, and then the courts, manned by the judicial officers, also do their own responsibility, try these offenders within a reasonable time, and then decide if they are convicted, fine and good, let them know the fate. And if they are not convicted, they are released at the end of the day, then tomorrow is another day. So, of course, unless we tackle some of these issues of biases in picking out who to prosecute and who not to prosecute, depending on his allegiance or his connections with some public officials who provide these monies, and also at the point of prosecution, also they need to be very, very diligent. The institution's prosecution should be very, very diligent and deliberate about it. And I think with some of this, we can be able to arrive at the promised land as far as combating money laundering is concerned.
Let's stay on that, Mr. Usman. I mean, I've been wondering, why is it always very hard for us to go after the big fish? I mean, most times we always run after the small fries.
Of course, Nigeria is the kind of society whereby sometimes some things happen that are even unexplainable. But then, for a fact, you will agree with me that the small fishes, if I may put it in your context, are easy to locate. They are easy to track, and then they are also easy to prosecute. Most at times, I handled the matter of recent whereby some individuals were prosecuted and also were convicted by the Economic and Financial Crimes Commission in respect of charges that has to do with money laundering before the Federal High Court. But it will surprise you to know that we got to understood that underneath the Economic and Financial Crimes Commission was striving to aim at a particular person who is suspected to have gotten the funds which my clients suspected to have fronted for him. But then they could not be able to do that because the big fishes always, they have their ways. I don't know how, but then I know they are very good in burying evidences. They are very good in cutting corners. They are very good sometimes bribing public officials as suspected. So there are many issues. But then the small fishes are the ones that always carry the cross at the end of the day. But money laundering cannot persist and cannot continue to exist as far as those big fishes are not confronted by the law.
Right.
Unless we do that, then the problem will still persist.
So talk to us about the key laws and regulations governing anti-money laundering. How effective are these legal instruments in tackling money laundering? I mean, if we ever consider the regulatory overview of the Money Laundering Act, how well are these laws being enforced by relevant agencies, talking about EFCC, ICPC, NFIU, and the likes? What challenges do law enforcement agencies face in investigating and prosecuting money laundering cases?
Yes, of course. The legal and institutional framework of combating money laundering in the Nigerian context is very sophisticated, I would say. because even with the 2011 Money Laundering Prohibition Act and then the recent amendment of the year 2022, which is a Money Laundering Prevention and Prohibition Act as amended, I think the provisions are very, very elaborate. They're very, very sophisticated. They're very, very okay as far as combating the menace of money laundering is concerned. They are very perfect. But then, of course, there has to be hitches in one way or the other. And these hitches has to be addressed, if I will say, particularly from the level of sensitization. I believe there are a lot of instances whereby suspects or defendants will be taken to court on the charges that has to do with money laundering, but that these individuals in the first place are not even aware that there is a particular body or department of the Economic and Financial Crimes Commission that is charged with the issue of special money laundering control unit, whereby they are to be submitting returns of their transactions, whereby they are to register, whereby they are to be lodging updates of their activities at acts. But then because they are not aware, so sensitization is key. Unless the public are concerned, are also enlightened, are sensitized, particularly on the issue of non-designated financial institutions. A lot of them are not aware of that. So sensitization is key and is one of the bottlenecks that the prosecutors faced, because most people do not know that these things exist. That is one. And then two, investigation. Investigation is something that is legally and procedurally provided. It is categorical, whereby there is a poor conduct of investigation by the investigating agencies, then definitely it will not yield the expected result at the end of the day, because they will only end up taking the suspect or defendant to the court, but then the court has no option than to discharge and acquit the person, because there was poor conduct of investigation at that level. And also at the level of prosecution, possibly, let's say, before a court of law, of course, there are instances whereby these defendants, like I highlighted earlier, that they are working for some other individuals who might be very, very powerful, maybe within the corpus of the government. So you find out that there are delays in some instances, sometimes even deliberate delays. So when there are delays in prosecution of these matters, definitely the person who is defending the suspect before the court will be hammering on that, and he will take that leeway in order to convince the court that there is no diligent prosecution in this matter. And before you know, the charge will be struck out and these individuals will go scot-free. And also, again, one of the bottlenecks sometimes is the issue of plea bargain. Plea bargain is a legal procedure, of course, duly recognized by the law. It has its own modus operandi, but then there are instances where this procedure or this channel that is made available by the law is being abused. There are cases that ought not to have gone to plea bargain because of the nature of the sum of money, large amount of money that is involved, or the nature of the individuals that should be before the court and face a stern prosecution. But then they will only use the avenue of plea bargain, and then they will enter into an agreement. Before you know, they're out of it. If you realize at the end of the day, they are only meant to be punished very slightly, not corresponding to the offense which they have actually been subjected to have committed. So there are a lot of key issues which serves bottlenecks for the
and because
state.
We've seen, and because we've seen situations where account officers are also found wanting, what obligations do banks and financial institutions have in preventing money laundering? Are financial institutions doing enough in terms of know your customer and suspicious transaction reporting? Again, how is technology being leveraged when it comes to compliance?
Yes, of course. I would say from my little experience, financial institutions are doing well in that regard, because most of them are strictly corporate entities, and then they are working with up-to-date mechanisms of conducting their activities. So they are doing very well, and also their synergy with the investigating agency, particularly the Economic and Financial Crimes Commission, is unhampered. It is very okay. Where there are little challenges, I will repeat, is when it comes to non-designated financial institutions. These are other institutions where monies or illicit acquired funds or financial assets are buried with the aim of making them seem legitimate, making them seem obtained through illegal means. So with these ones, because of some issues, they are unable to be meeting up with the obligations or with the demands of the law. So a lot needs to be done in that direction. But then with the strictly financial institutions, they have little or no problems. Okay. With the issue of leveraging technology, I think in the part of the financial institutions, banks, and what have you, I think they leverage technology in that regard because the issue of the filings of some of the documents that are required as the law, as far as the law is concerned, most of them are done electronically nowadays. But with the non-designated, because they don't have these features, they don't have these gadgets to carry out such reports. So definitely they do them.
All right, Mr. Usman. But do you think the public understands the impact of money laundering on the economy and governance? Do you think so?
Actually, not to expectation. Likely not to expectation, because the public are not even aware.
We'll continue this conversation some other time. Sadly, we're out of time. I've been speaking with Muhammad Usman, lawyer, public affairs analyst. Thank you so much for your perspectives tonight.
Thank you for having me.